for a notice? It's on the record.
It's like contempt in the face of the court.
Exactly. It's on the record. Somebody who is taking this case, Eknath Shinde, who is the chief minister, he's the first person, he's one of the 16. How will he going to relate back?
The chief minister of a party completely loses the confidence of his own party in the house.
Yes.
Whether he has a confidence or not cannot be tested on the floor of the house.
It cannot be.
Which Speaker may do that.
Is that he can? I tell your lordship the reason. I give your lordship the reason. Supposing, Malaj, the house is proceeding, a whip has been issued, and 12 people defy the whip. Just because these are live examples. 12 people defy the whip. No matter what's the need for a notice? It's on the record.
It's like contempt in the face of the court.
Exactly. It's on the record. Somebody files an application that I'm seeking a removal. So under Narendra, he can't deal with it.
It has one very important bearing. That why do you attach the disability of the speaker the moment a notice under 179C can be given? The reason is that there is no real power or restraint on the speaker in proceeding with the greatest of alacrity on the disqualification.
But on the other hand, when there is a disqualification,
that seems to be the logic.
That's fine. But on the other hand, when there is a disqualification, it has to proceed with alacrity. Otherwise, the government will be toppled. There are two issues here. What has happened today is, Bharat, somebody goes to Gujarat, goes to Assam, passes resolutions, removes people, and that is not considered to be discriminatory.
My brother just mentioned, if with his permission, I'll share. It's not always that the speaker will act with alacrity to disqualify. In a given case, he will be sufficiently emboldened. No, he may decide not to take a decision also.
That's right, Manoj. We have seen that in Goa. We have seen that in many other places.
It works. It depends
on who is in power.
Exactly.
So, Manoj,
then we go on to have an early decision.
Well,
lay down is very difficult because
very difficult then.
Very difficult. In fact, each case is a discipline itself. So, to formulate a principle with respect to at what time the speaker is to act and go down as a principle is difficult. But the legislatures and parliament has made rules with respect to when he should act. That discretion is a problem.
Because
in one case he will act.
The moment they're only concerned with one issue, whether at the time of issuance of notice, the disqualification to preside occurs. That's the only issue we're concerned with. We're not concerned with any other issue.
The only answer to it is whenever at whatever point of time the case is finally decided by the speaker, it will relate back.
Yes.
If it relate back, all this is irrelevant.
No.
It relates.
Mulat, in the meantime,
decides today your argument is to be accepted. It always relates.
Mulat, but in the meantime, a legally elected government has been toppled by virtue of the fact that the disqualification will not be decided. The fruits of the poisonous tree are being enjoyed by somebody else.
And replying to your submission on it. And that it should relate back to that and say,
no, that's all right. But it will relate back after 2 years, relate back after 3 years.
Relate back is either in the context that your lordship would then allow a disqualified LLA or FE to be able to do something. If it relates back, at least that person who is given the notice is entirely disqualified. He can't, that is the context in which he's arguing. That your lordship cannot then allow me to have the status of a person with a given notice.
Who is taking this case, Eknath Shinde, who is the chief minister, he's the first person, he's one of the 16. How will it going to relate back? In the meantime, a government has been toppled. So, these are very vexed questions that your lordship will have to look at Raman Bedia, see how to answer.
Mr. Sibbal, there's another aspect also of Nabam which has been worrying us. We've been in discussion, which is that ultimately in any constitutional adjudication, Nabam lays down a principle. Now, we have seen how vexed it can be in the sense that, it really depends on the emerging political situation from case to case, stage to stage. Now, Nabam has laid down a principle which is holding the field until today. But before we decide to enter upon this to review the correctness of Nabam, we must also be clear that it, strictly speaking, arises in a case. Now, one thing which you have to really perhaps assist us on is this. Nabam, the correctness of Nabam would arise if the speaker stood injuncted either by the High Court or by this court from exercising his powers under the 10th schedule. If the speaker was injuncted from exercising his powers under the 10th schedule until the vote for his removal was taken up.
Right.
Or he himself says that, look, in view of Nabam, I'm not going to exercise my right. Then somebody else may say that, well, you have to exercise your jurisdiction. Now, in our case, what happens is that when the speaker perhaps in that sense created a problem for himself, made it out of the political exigency. We're not at all saying that in a pejorative sense. That's real politics. The speaker himself gave only 2 days notice. 25th, he said, I'm going to give you, I'm going to give you time until the 27th. Our court, in the light of that, said that time to furnish your reply is extended until the 12th of July.
In the interim, your worship may not have looked at that phrase.
Yeah, in the interim.
In the interim,
Now,
it is extended.
a trust vote takes place.
Yes.
The then government decides not to face the assembly, it resigns.
Right.
Therefore, what impact the vote or non-vote of these people who were sought to be disqualified by the speaker would have was never tested on the floor of the House.
You told the fourth it was tested.
The resignation.
The fourth it was tested.
No.
Yes.
On the resignation, the resignation of the Chief Minister obviated a reference, obviated the floor test.
No, therefore, it happened on the
30th itself.
before Sydney. It happened. Well, the same thing.
But on the 30th, what happens is this. On the 30th, when the floor test is to take place, the government resigns on the 29th.
Right.
The moment, of course, they got to know that the floor test is going to be held and there is no stay by the Supreme Court. Now, as a result of that, what happens is that the vote which would otherwise have been cast by a person who was sought to be disqualified on the overall voting pattern never emerges before the assembly. So in which case does really Nabam Rebia, does the correctness of Nabam Rebia fall for consideration?
Yes, but I will demonstrate that immediately.
And should we go into the validity of Nabam Rebia? Really, because obviously very interesting constitutional issues arise. Because when we decide a constitutional issue in the absence of a factual background, let's say that the court is trenching upon something without full facts.
Situation where it's not really a case of an anti-defection. It's a case where there's perhaps a realignment, even a starker case than this, where there is actually realignment is going on. And the Chief Minister is in an awfully minority. Then, knowing the writing on the wall, the Speaker would want to declare all the others who are on the other side as violator of.
He considers, as he can't invest further, there's a petition before him.
Petition. That's another.
Yeah.
Petition part of it is what you are saying, this application, this notice is actually not equivalent to a petition. We are on the interpretation. We are on the question of should the Speaker restrain or postpone it till some point of time. We are only on that question. In a situation like this, in order to preempt a situation, Speaker takes up the matter and immediately disqualifies them.
Let me ask that. Very pertinent question. Let me ask that. Let's now bifurcate this. One, we can't have a notice before a petition for disqualification. That's one part. You can only have a notice after the petition for disqualification.
Okay, that point is taken.
Good. Until the notice is the next. Now, supposing there's a notice after the petition of disqualification. In that event, everything would have happened already.
Suppose there is
The facts would have happened already, because the notice will have to be based on
this is based on where a notice is there. Take a situation. Assuming for a minute that this 20, instead of 21st, it's a 20th notice. Then what is
not 20th, 21st.
There is a notice on 10th schedule.
Yes.
Already given by one of the minor members. Then what will happen?
I tell you, Lordship,
Then the Speaker proceeds further to disqualify all of them.
Why not? Because that's the law. That's why I said under the 10th schedule, there is no minority issue. There's only a water issue.
So therefore,
There's no defense under the 10th schedule.
about 2 days' time, he proceeds to consider the 10th schedule and immediately he passes.
But Manoj, if out of 55 or 58, 40 are on the other side, it's covered by the 10th schedule. Because there's no defense. Whereas, as your lordship knows, under the 10th schedule, you are given only defenses. If there's a note, if there's an application for disqualification, there is only a defense available. It was available Manoj, under paragraph 3, 1/3 of the members of the legislative party Manoj, decide to join the other. That was the defense available. We are 1/3. Right. Now, that also has gone. So there is no defense of saying, I am in majority. Your lordship is now making a hard fact situation that the chief minister has lost confidence. Actually, he's only 50 people are out of 50, 40 are to the other side. I was that against myself. Right? Now, there are still some of it is disqualification. So what? That's why, because I said, these majorities can't be decided in the legislature. What they have to do is go to the party, come out, and come to the house.
No, there before this. No, all that time is not there. By the time they go to the party, to the election committee.
That is why, Milad, that is precisely my argument.
Therefore, Mr. Sibbal, your argument, I mean, stretched to its logical conclusion would mean this, that even if the chief minister of a party completely loses the confidence of his own party in the house,
Yes.
whether he has a confidence or not cannot be tested on the floor of the house.
It cannot be.
Which means that, according to, therefore, that a chief minister and a willing ally in a
The speaker will have to be with him. At least 2 people will have to be.
people have to do in the court, because we're not dealing with a defection.
No, I understand.
Where you lose your own party,
But
then you've lost your own party.
I tell your lordships, then what will happen? It's very simple, Mullah, then what will happen? Then what will happen is that under the scheduled Mullahs, the speaker will be removed. Without anything, without any other thing, Mullahs. The speaker, when a motion will be passed or whatever, the speaker will be removed and another speaker may be installed. But that's another issue. That's a question has not arisen. At the moment, we are Mullahs on what? From what date does the disqualification of the speaker commence?
Important question about.
That's all. Now, let me now read something about the Constitution itself.
Yes.
For a minute.
No, I think you've now made your submission on the reference or the lack of reference.
I'm sorry.
The same thing, whether the reference needs.
Right. No, this one other. Yes, this one other thing. Yeah,